looking down at my phone, that doesn't mean I'm inattentive or doing something else. It just means I'm using my phone to time the arguments. So to my right is Judge J.C. Hurst, and to my left is Judge Leslie Ann Isherwood, and we make up the panel hearing the cases this afternoon. So we'll go ahead and get started. The first case of this afternoon is from Johnson County, case number 126794, Catherine Short, appellant, versus Michael B. Robertson, MD, the appellee. We could have counsel come forward, please. Okay, and I'll note that we have no one appearing on behalf of the appellant. Appellees, if you could state your appearances, please.
Your Honor, my name is Mark Lynch. To my right is Brenna Lynch. I represent the appellee. Brenna Lynch will be arguing.
Okay, and considering we have no appearance on behalf of the appellant, counsel, if you would like to argue, we can proceed with arguments. We can also consider the case submitted on the briefs. I'll leave that all in your court.
Your Honor, we'd like to argue.
Okay.
We'll try to truncate that and address whatever questions the court may have from our standpoint, but we would like to go ahead and present.
Okay, perfect. Then you have 15 minutes to present your arguments.
Thank you, Your Honor. May it please the court. Good afternoon. Again, my name is Brenna Lynch on behalf of the appellee, Dr. Michael Robertson. I'll keep my remarks brief. As I'm sure the court is aware, there were two main issues in this appeal. I'll start with the first one, which was the issue of jury selection. The claim being made, or reason for the appeal being made, was that this was a rather unique method of jury selection. The town hall format, as it was referred to by the trial court. Essentially, the case law in Kansas, or lack thereof, does not establish a prescribed method for jury selection. So it is soundly within the trial court's discretion that how jury selection is conducted, and it's within the trial court's discretion about, as long as it's fair to both sides, essentially is the issue, that if we're going to do a unique method, that's kind of what we need to look at. So in this case, there was ample time given to both sides to examine this jury panel. We spent an entire day in jury selection, wherein both sides were allowed to select topics, an alternated selection of topics, as well as alternated questioning individual jurors who had affirmative answers to the questions or otherwise wanted to discuss those topics. There was no restriction on time or subject matter by the court. There was no restriction by the lawyers on each other's time or subject matter. So each side was able to discuss the topics that they wanted to discuss. There were several jurors mentioned in the briefing that were pointed out as examples of this being a confusing or disjointed process. Two of those jurors I'll talk about very quickly. They were the two dismissed on day 4 of the trial. And what I'll say about those is the reasons for their dismissal were not unique to the method of jury selection in this case. They had identified at some point during the presentation of evidence that they had more knowledge or familiarity with some of the witnesses or the topics being discussed than were realized in jury selection. And that is an issue that could happen in any jury selection, not just in this town hall format.
Do you think this method created the higher probability or possibility of that happening, or increased the likelihood? I mean, 2 jurors is not an insignificant amount of jurors to be dismissed in a weak trial.
Sure. The short answer is no. I'll take each juror individually. So the easiest one to talk about is juror NV, who was dismissed because of his familiarity with one of the witnesses. And that came up because her married name was used when we give a list of potential witnesses during jury selection. He did not know her married name. He only knew her by her maiden name. And only when he was able to understand her profession, basically, is when he recognized who it was. So again, the method of jury selection would not have changed how we identify that witness. Juror JW, who was the one who realized that she was more familiar with this plaintiff's reconstructive surgery than was initially identified in jury selection. Again, not a result of the method of jury selection. It was simply a result of neither side's counsel recognizing that there needs to be more examination into that particular procedure or group of procedures after the removal of the breast cancer in this case. So that was the plastic surgery. Neither side recognized that that was an issue that needed to be further probed by any of the jurors or JW. So the other juror that was identified was juror JH. This was the juror who was ultimately struck from the panel using one of plaintiff's peremptory strikes. There were 3 separate occasions on which juror JH was questioned by plaintiff's counsel. There was ample opportunity to understand this juror's position on her self-stated opinions or biases on medical malpractice cases. So the first being that she rated herself on the 1 to 10 scale at a 7 or 8, 5 being the neutral. Then she was moved on from, and other jurors were questioned on that same scale. Second occasion, the court at that point had described the evidentiary standard in the case being the preponderance of the evidence standard. On the second occasion that she was questioned, she acknowledged that she could follow that. Again, she was moved on from, nothing else was asked of her substantively. And only on the third occasion that she was questioned, did we get a little bit more understanding on why she rated herself in the way she did, the types of biases she self-identified herself as having, and ultimately did not demonstrate, and the standard is insurmountable bias. So we assume and understand that most, if not all, jurors who come to sit up on a veneer panel are going to have some sort of bias or some sort of predisposition to a type of case or type of issue, no matter what. And there's really no way to completely sanitize your jury of all of those people. The standard is, do they have an insurmountable bias? And the court in this case did not find that juror JH demonstrated an insurmountable bias. So it was within the court's discretion to deny the motion to strike her for cause. And that really isn't even the use of the court's discretion that is being appealed here. It's more being used as an example of the confusion or the disjointed process. So the appeal is not, was it an abuse of discretion to deny the motion to strike for cause? She's simply being used as an example. If there are no more questions on issue 1, I'll move on quickly to issue 2, which is the use of exhibit 16 in closing arguments. There's no question that this was an admitted exhibit. It was admitted by plaintiff by stipulation before they even called their first witness.
Counsel, I'm sorry. Can I briefly bring you back to issue 1? I think you mentioned it in your briefing, but just to clarify, and I realize appellant's not here for us to ask this question, so now I'm going to ask you. But in their docketing statement, they do specifically say that they're appealing from the district court's refusal to strike certain jury members for cause. But in my recollection in their briefing, I think it was more what you described, in that they were using those jurors as examples for the overall process. And is that how you see this as well?
That's correct, Your Honor. And the reason that we decided to address this issue, however briefly in our brief, was because they put it in the docketing statement. But it is correct that they did not further elaborate on that or make it an issue in their full brief.
In which case we would consider that waived then,
Okay.
correct, or abandoned? I mean, that's your argument, I assume.
Yes, that would absolutely be our argument. We felt that we needed to address it, however, briefly, just in case the court might be concerned with that issue and because they put it in their docketing statement. But otherwise, I would agree with the court that that is not an issue that they've brought in their brief, and we would argue that it's been waived.
Okay, thank you.
So issue 2, the use of Exhibit 16 in closing arguments, again, an admitted exhibit by stipulation at the opening of evidence in this case. So there's no question that use of Exhibit 16 or comments on it were outside the evidence. So that's from the Pot case that as long as counsel is arguing within the evidence and making reasonable inferences from that evidence, it's within the court's discretion to allow that argument. And in fact, counsel is given wide latitude to make those types of arguments in closing. The reasonable inferences that counsel made from this evidence is important because of the context of all the other evidence in the trial. So it was not that Exhibit 16 was shown to the jury in a vacuum. They had at that point almost 4 full days worth of evidence wherein the characteristics of and the use of this Copans wire or this hook wire is used. They heard that from multiple witnesses. They saw it from multiple other exhibits and demonstratives that we used. There was expert testimony, particularly from our expert, Dr. Kuckelman, on this type of wire, its unique characteristics. And that unique characteristic being that this is not a hook wire in the sense you might think of the shape of a fish hook. It's actually further bent back onto itself, such that there's a loop at the top and then a trailing tail down here. It is very unique and is easily identifiable by both the naked eye and through imaging like x-rays. The jury had seen the other specimen radiographs, so that would be Exhibit 13 of this Copans wire, this hook wire, in its abnormal configuration that we then argued was the result of that wire being tugged on and pulled further out of its configuration. So by the point or by the time of closing argument, the jury has heard described and shown to them the unique characteristics of the wire, its usage. They've seen other specimen radiographs, so they know what they're looking at just grossly, what specimen radiographs are, and how that wire, even in its abnormal configuration, would look in those specimen radiographs. So the jury had lots and lots of testimony and other evidence to provide context for what they're viewing in Exhibit 16. And the use of Exhibit 16 was to provide a contrast to Exhibit 13. So again, reasonable.
Objection isn't about the use of 16 though, is it? Isn't it about the statement that was made about 16?
That's correct, Your Honor. I believe counsel argued that essentially defense counsel was arguing outside of the evidence, or that there was no expert testimony to support counsel's argument, which is incorrect.
So, okay. What statement do you think that they're objecting to that was made in closing?
Well, Your Honor, I would have to go to the exact quote from defense counsel in order to answer your question fully.
Well, I don't want to make you search through, but the way I understand it is they're arguing that the legal expert opinion was given from counsel regarding why 16 looked the way it did. And are you saying that you don't think that's what the argument, like the statement that was made?
Well, that's certainly not what the purpose of the statement was. Counsel was not trying to give a medical opinion or an expert opinion on Exhibit 16. Counsel was using Exhibit 16 as a contrast to Exhibit 13, for which plenty of information and context was provided to the jury through other evidence, other exhibits, demonstrations, testimony from expert witnesses. So Dr. Kuckelman on the defense side, and I believe even there was some discussion about this Copans wire with plaintiff's expert, Dr. Ismaili. So counsel was not making an expert witness opinion or a statement that would be more proper for an expert witness to make. Counsel is making a reasonable inference, or inviting the jury rather to make a reasonable inference about what they're viewing in Exhibit 16. And the idea that expert witness testimony is necessary to discuss evidence in closing argument really isn't the whole picture. Expert witness testimony is needed to establish a prima facie case of medical negligence. This was an exhibit. So in other words, the expert testimony is needed to establish foundation for certain types of information, certain exhibits. This was an exhibit that was already admitted. So the foundation has essentially already been stipulated to.
Right, but not that one is normal and one is abnormal, but and to why one is normal looking and one is abnormal. I mean, that's the conclusion that the jury is supposed to draw themselves, right?
Yes, Your Honor. And there was lots of evidence prior to closing argument in the case on what a normal Copans wire looks like versus an abnormal Copans wire.
Was there testimony that Exhibit 16 was a normal Copans wire?
There was not testimony on Exhibit 16 specifically, but again, the unique shape of this wire, which is clearly visible in Exhibit 16, was discussed through other evidence and described through testimony of both Dr. Robertson and the experts in the case.
So let's just assume, if we just assume that the discussion about Exhibit 16 in closing was an error. In your briefing, you mentioned that plaintiff has not shown she was prejudiced. And I'm not positive that the parties actually got the burden wrong on who has to show that prejudice, because you would be the party benefiting from that error, correct? So then is it not your burden to show that there was no prejudice?
I don't believe that's what the law says, Your Honor. There's a certain case that you.
I was looking at Castleberry. It's 308 Can 791, and in that case, it does say the next question is whether there's a reasonable possibility this error affected the verdict, and we've made clear the party benefiting from the error has the burden to show harmlessness. Now, that might be in the context of, I can't recall if that's a constitutional error, and if we're looking at the same thing, but that was a medical malpractice case. And so I'm just curious if that is something that you've looked at, and if it were your burden, what would you argue?
So first of all, I'm generally familiar with the Castleberry case, not the particular quote that you have given. But if the burden were on us to show that it was not an error,
Not prejudicial.
not prejudicial, thank you, Your Honor. The first thing that I'd point to is the jury is given an instruction that arguments of counsel are not evidence. And there is a presumption in Kansas law that juries follow those instructions. So if counsel's statements are the error, then that error is then overcome and is harmless because of the instruction. The instruction cures that, and there is then no prejudice to the plaintiff. But more importantly than that, I think I'd just point to the record that there's nothing in the record that demonstrates that the jury took counsel's arguments as evidence, or that it created a prejudice against the plaintiff. There's just simply nothing in the record. So
Would that be because the evidence in the record demonstrated what counsel said already? There was evidence throughout the trial that supported the statement. So even if they believed it, they were relying on evidence already in the case.
I would agree with that statement, Your Honor. And that goes back to my major point on this particular issue, is that there was an abundance of other evidence in this case that gave context to Exhibit 16. So even setting aside counsel's comments, which is what the jury is instructed to do, They still would have had Exhibit 16 back with them in the jury room and were completely entitled to view it and make their own assumptions from it, and had extra information that they were provided through expert testimony, through Dr. Robertson, and through other exhibits that could have informed their understanding of what they were looking at in Exhibit 16.
Since you were the only appearing party, I've let you have some pretty wide latitude. We're at 18 minutes.
Okay.
So if you would like to sum up, if there aren't any other questions, if you want to sum up.
I don't have anything else additional to add, Your Honor. I appreciate the extra time. I would just ask that the court affirm the trial court's decisions in this case. There was no abuse of discretion on either issue, and we ask that you affirm that ruling.
Okay, thank you. Okay, we will consider the case submitted for decision. We'll take it under advisement and issue a ruling as soon as we can. Thank you.